The court is going to give the parties the overview of the court's ruling, then it will be followed up by a written order. This matter has come before the court on the state of Florida's motion for court order finding Rosita and Hal Donaldson Jr. in indirect civil contempt of court filed on January 25, 2018. Previously, the state had filed its motion for court order to show cause as to why Rosita and Hal Donaldson should not be held in contempt of court on December 6, 2017. On December 7, 2017, the Honorable Margaret Taylor issued an order ordering the defendants to appear before the court to show cause as to why they should not be held in indirect civil contempt for failure to comply with the investigative subpoena issued by the state attorney's office and served on them on December 4, 2017. After reviewing the court file and listening to arguments of counsel, the court finds as follows. The court finds that the defendants have been properly noticed of the proceeding. The court finds that the defendants have willfully violated the order contained in the December 4, 2017 investigative subpoena, requiring them to appear before the state attorney's office and provide testimony pursuant to the purposes of their investigation pursuant to Florida Statute 2704. Further, the defendants have refused to avail themselves of the purge provision as contained in the December 7, 2017 order, which allowed them an opportunity to purge the contempt citation by appearing before the state attorney's office at any time during the business hours and providing truthful testimony regarding the matter. The court also finds that the defendants of all time from the date of the investigative subpoena and the December 7, 2017 order have had the present ability to appear before the state attorney's office and provide truthful testimony. Notwithstanding that, the defendants have willfully and intentionally refused to provide truthful testimony as ordered through the investigative subpoena and the judge's order. The court finds that the defendants have not invoked any statutory privilege or any privilege under the United States or Florida Constitution that would allow for their declaration to provide truthful testimony. And the court finally finds that the defendants have the present ability to purge themselves from contempt by appearing before the state attorney's office and providing truthful testimony. It is therefore ordered and adjudged that the state of Florida's motion to find Rosita and Hal Donaldson Jr. in contempt of civil contempt is hereby granted. It is further ordered that the defendants will be confined to house arrest for a period not to exceed 5 months and 29 days for indirect civil contempt. The defendants may purge themselves of contempt at any time if they choose to do so by appearing before the state attorney and providing truthful testimony. Because this court is mindful of the difficult situation that the defendants are in, the court is modifying the house arrest to allow them to have medical, religious, and employment purposes as exceptions to the house arrest. After the house arrest period is completed, if the defendants continue to be in non-compliant with the court's order, the state may proceed in any manner they deem appropriate. Is there anything else from the state or defense?
Nothing from the state, Your Honor.
Procedurally,
at this point, we need to make arrangements for the house arrest. And is it normally going to go through the bailiff's office? The sheriff's deputy, they usually take them into custody and then they go out into the house arrest program?
Unless they are, unless they find a private house arrest company or private monitoring company in Washington.
At this point, we have no private monitoring. We'll be monitoring through the jail, so they would be taken into custody.
Your Honor, I think there's an alternative to that through private monitoring.
I'll be happy to listen to it.
Would you like all the parties at the podium, Judge?
Let's have the two parties come up, please. And then I'll be happy to listen to alternative arguments. Mr. and Ms. Donaldson, please come forward.
I think a commercial surety, Mr. Alvarez is the one who seems to be more familiar with that process.
Mr. Alvarez, would you like to provide the court with information regarding this matter?
Your Honor, in the past, at least when we have people out out on bond who are
I know
being
we have the
monitored, we can
pretrial
line it
monitor,
up.
we have the issue, we have the pretrial monitor, for
Correct.
example.
And so I was wondering if we could have some time to try and set that up through
right,
a
you're
private monitoring
requesting-
service.
You're requesting that they be on a GPS monitor in lieu of being taken into custody?
I believe that would be appropriate, Your Honor, if you would be so inclined.
State, do you have any objection?
No, sir.
All right, so what was the situation we need to do to make sure that this is done, and how much time do we need to do it?
I don't think it's much time, Your Honor. We can maybe come back as a status next week, just to let Your Honor know that we have lined up the surety service and that all has been taken care of, or if the court would even allow us to maybe file something by Tuesday to let you know that they are being monitored and by whom.
That way also, Mr. Pruner can review and make sure everything's appropriate. I'd hate to have a routing through the jail system
All right.
unnecessarily if that's
All
not.
right, so basically what you're asking me for is to set this matter on Tuesday, the 20th at 9 o'clock on my regular pretrial docket to allow you all to come back and show me that they have been placed on a GPS monitor and the situation is set up for the house arrest program.
Right.
State, do you have any objection?
No, sir.
And defense, will you provide the documentation to the state by Monday so they can come back on Tuesday and
As
say
soon
they're
as-
agreeable?
Yes, Your Honor, and as soon as I have it, even before then. Contact has never been a problem between us.
All right, then that's how we'll handle the matter. I will set the matter for Tuesday. If your client, Steve, you have no objection, if the defendants have been placed on the GPS monitor and you're satisfied with the paperwork, can we waive their presence for Tuesday morning if it's simply a matter to verify that they are in fact in the program?
No objection to
All
that.
right, is that what you're requesting?
Yes, Your Honor.
All right, then I will allow the defendants not to be present as long as the GPS monitor situation has been resolved and the state and defense are agreed to it, all right?
Thank you, Your Honor.
Anything else from the state or defense?
No,
Your
Your Honor.
client, you'll discuss with your clients how they can purge this matter as hopefully as soon as possible.
Yes, Your Honor, I will do that.
Thank you.
Thank you, Your Honor.
Court's adjourned.